What's up guys, welcome back. So as I said in my earlier video that I would take the RPQ on the registration and the transitional provision. So here is my first video which is regarding the RPQ on the registration. But before to start the video, I want to tell you something that is important to you right now. And this is a very good news for those people who wanted to start the businesses and waiting for the date of newly registration, fresh registration under the GST. So let me just tell you something that is very important to you right now. So the date of application for filing to register under GST has now been announced on 25th June 2017. So as you can see also on your newspaper that in the advertisement it is written that you can newly apply for registration under GST with effect from the 25th June 2017. And also all the provision which is regarding the registration like section number 1, 2, 3, 4, 5, 10, 22, 24, 28, 26, 27 and all the chapter regarding the registration, all the legal provision relating to the registration has been come in force with effect from 22 June 2017. So that is a very good news for those people who was waiting to start their businesses but they are hesitating or they don't want to start because of the GST. So after or on 25th June 2017 onward you can now register under GST, and if you are wanted to start the your business, then you can do your business with effect from the 25th June 2017. And second one is for those people who already migrated into GST. They have the concern like what will be their GSTIN, because in GST you have to mention the GSTIN on your invoices or for dealing out with other people. So they have the confusion like because they have migrated into GST and they didn't have any GSTIN. So what they will mention in the invoices. So let me just tell you something. You can use your provisional ID as your GSTIN. You can use your provisional ID as the GSTIN for doing your businesses. So it means that you can write the provisional ID in your invoices or for dealing out with the people. So that is also a clarification which I want to tell you right now. So now coming back to our RPQ, today we will discuss about the RPQ on the registration. And the question would be like, what will be the case, what will be of those person who wholly engaged in the exempted supply or partly engaged in the exempted supply of goods or services, whether they need to register under GST. Or for those persons, suppose they are making 19 lakh rupees of turnover in exempted supply of goods or services and 2 lakh of taxable supply of goods or service, whether they need to register under GST. We will discuss it. And then second one is about the implication of those person who are registered under GST. So someone asked me a really cool question. They said, suppose my turnover is 20 lakh rupees in this year, so I have registered under GST, but in the next year my turnover is up to 18 lakh, so whether we need to pay tax under GST. So we will discuss it here also. And then the rectification in the registration detail. So a lot of messages is circulating in the WhatsApp group like you cannot rectify anything in the GST, like you cannot rectify your return, you cannot rectify the tax paid mistakenly. Suppose you paid the CGST SGST instead of IGST, you cannot do it. That is also messages which is circulating in the WhatsApp. And also like you cannot rectify any mistake which you done in the registration form. So we will discuss that how we can rectify those mistakes, or if the GST law allow us to rectify those mistakes, we will discuss it. And then section number 22 subsection 2 gives the power to the government to notify any category of person to exempt to register under GST. So we will discuss that whether there is any notification issued by the government till now, and the date of recording this video is 24th June 2017. So we will discuss that whether on 24th June 2017 there is any notification which allows a person to not register under GST if they satisfy some kind of a condition. So we will also discuss it here. So this is going to be very interesting video or very knowledgeable video to those people who has the query regarding the registration. So without any delay, let's start. So this is our first question of this RPQ, and the question is regarding those person who supplies the export, who makes the export to the other country and also supply the goods or services within India. They are doing the both thing, exporting as well as selling the goods or services within India. And the question is that whether a person need to register under GST if he is making export of rupees 19.5 lakh and supplying only 1 lakh in India. So the concern of the people is that they are exporting to the other country and they are also making the domestic supply. So whether they need to register under GST in case their turnover aggregating both the supply exceed the 20 lakh rupees. So their concern is also very genuine. So before to answer this question, let me just tell you something, that who are the person who need to register under GST. As per section number 22 subsection 1, the person whose aggregate turnover exceed 20 lakh rupees need to get yourself registered under GST. So if you have the aggregate turnover exceeding 20 lakh rupees, then you need to take yourself register under GST. But what exactly is the meaning of aggregate turnover? We have to check that. So section 2 subsection 6 tells us, give the definition of aggregate turnover, and if you look at the definition, it says that the aggregate turnover means a lot of things, which also include the exempted supply and exports of goods or services. So that is the extract of section 2 subsection 6, which give us the definition of aggregate turnover. So the aggregate turnover also include exempted supply as well as export of goods or services. So in our example, the turnover, the export of goods or services was 19.5 lakh and the domestic sales was 1 lakh. So it means that the aggregate of both two is 20.5 lakh, which exceeds the limit, which is threshold limit prescribed under section 22 subsection 1. So therefore, because aggregate turnover include the export as well as exempted supply, so therefore we have to add both things, export as well as domestic sale, for checking out the limit of checking out the threshold limit of 20 lakh rupees in section number 22 subsection 1. So in our example, because the export was worth of rupees 19.5 lakh and the domestic sale was of 1 lakh rupees, so combining both two, the answer is 20.5 lakh. So it exceeds the threshold limit which is prescribed under section 22 subsection 1, which is 20 lakh rupees. So therefore in our example, the aggregate turnover is 20.5 lakh, which exceeds the threshold limit. So therefore those person whose turnover exceed 25 lakh rupees, including both the exempted, the export or the domestic sale, need to get yourself registered under GST. But also one more point here to note is that the exempted supply and the export is different thing. Export is zero rated under GST and exempted supply is very different. So if you are exporting the goods or services, then it don't mean that it is exempted under GST, although it is zero rated under the IGST Act, but that is not an exempted supply. So make that point into your mind, or make that differentiate into your mind, that export is different from exempted goods or services. Exempted is those who are nil rated or are not liable to tax under GST, but the exempted supplies may be taxable under GST, because the supply of those goods or services have some kind of a rate prescribed under the rate schedule, which is approved by the GST Council. But the refund will be get of those person who exports the goods or service. So therefore export is different concept and the exemption is different concept. So don't mix export with the exempted supply of goods or services. And the next question is for those person who supplies only the exempted goods or services. And the question is whether a person who are supplying only exempted good is required to take registration under GST. So you are a person who engage wholly or exclusively in the business or supply those goods or services which are exempt under GST. So whether you need to register under GST. So suppose you have a turnover of 1 crore rupees, but that goods or services is completely exempt under GST, or you don't supply any other goods or services which are taxable under GST, then whether you need to register under GST. So the provision which deals with such kind of a situation is given under section 23 subsection 1. 23 subsection 1 deals with those situations in which you don't need to get yourself registered under GST even if your turnover exceeds 20 lakh rupees in the financial year. So the 23 subsection 1 says that you don't need to get yourself registered if you are engaged exclusively. The word is exclusively, which means completely or wholly. So if you exclusively engage in the business or supplying of those goods or services, which are completely exempt under the GST, then you don't need to get yourself registered under GST even if your turnover exceeds the 20 lakh rupees. So the words is exclusively. So suppose you are dealing in a goods or services which is totally exempt, and also your deals in such goods or services which is also taxable under GST. So suppose you deals in two type of goods. One goods is completely exempt and second one is taxable. So in that case you cannot take the benefit of section 23 subsection 1, because the word is that the exclusively. So you should exclusively supplying those goods or services which are exempt under GST. So even if you supply the goods or services of 100 rupees or 1000 rupees or 1 lakh rupees which is taxable under GST, then you cannot take the benefit of section 23 subsection 1, because the word is exclusively. And also, if you want to know what exactly is the meaning of exempted supply of goods or services, then the definition of exempted supply is given under section 20 under section 2 subsection 47, and it says the exempted supply is those which attract the nil rate of tax or which are wholly exempt under section 11. So if you supply those goods or services which attract the nil rate as per the rate of schedule or which are wholly exempt under section 11. Section 11 gives the power to the government to notify any goods or services which will be completely exempt under GST. So if your goods is the rate of goods in respect of your supply goods or services is taxable. Suppose the tax is 12%, but the government come up with a certain kind of a notification in which they gives you the notification to exempt such goods or services, then also that will be called exempted supply, because these two things in section 2 subsection 47. First one is that those goods or supply which attract nil rate or which are wholly exempt under section 11. So that is the definition of exempted goods or services. So if you supply exclusively in the business of those goods or services which are wholly exempt under GST, then you don't need to get yourself registered under section 23 subsection 1. But suppose you also deal in those goods or services which is taxable under GST, then you cannot take the benefit of section 23 subsection 1. The next question is very practical question. It is regarding those person who have taken the registration under GST, but in the subsequent year their sale is below 20 lakh rupees. Then he want to ask that whether he need to pay tax under GST. And the question is, if we are registered in 1 year because sale or supply exceeds the 20 lakh rupees, but in the next year the sale is below 20 lakh rupees, then whether we need to pay GST next year also. So the query is regarding those person who have the aggregate turnover exceeding 20 lakh rupees in a particular financial year. So if the turnover exceeds 20 lakh rupees, okay, son, he has to take registration under GST, okay. But in the next year or 2 or 3 years after the registration, his sales decrease the 20 lakh rupees threshold limit. So suppose his business is losing or his business is diminishing. So whether he need to pay tax under GST even if his aggregate turnover is below 20 lakh rupees in the subsequent year? So the answer is yes. Because look, you have to pay tax and all the provision of this act will be applicable to you as long as you are registered under GST. So if you are registered under GST, then all the provision of this act including the payment of tax will be applicable to you, and all the provision of this act like the payment of taxes, input tax credit, registration, return, accounting, assessment, appeal, and all the provision of this act will be applicable. All the provision of this act will be applicable to you as long as you are registered under GST. So therefore, if you are registered under GST, then you have to pay tax also, and all the provision of this act will be applicable to you as long as you are registered under GST. And also, if you check out that everywhere in the act the wording is registered person or the taxable person. Every single section, every single chapter of CGST or SGST act starts with the registered person or the taxable person. So if you are registered person, then it means that all the provision of this act will be applicable to you. And if you want to know about the taxable person meaning, the taxable person meaning is defined under section 2 subsection 107. It says that the taxable person is those who are registered under GST or who are liable to register under GST. So it means that you can say that the taxable person also means the registered person. So therefore, if you are registered, then all the provision of this act will be applicable to you. So even if your turnover below 20 lakh rupees and you are registered under GST till now, then you have to pay tax under GST. You cannot take the benefit of 20 lakh rupees because that is for the first time when you start the business or when you opt to take register under GST, because your turnover exceeds 20 lakh rupees. But in the subsequent financial year, also when you do the business and when you supply the goods or services, you need to pay tax under GST even if the turnover is below 20 lakh rupees. But what is the solution? Because you are a small supplier, so suppose your turnover is decreasing in the subsequent financial year and now you become the small person. So that cannot be happen that you will have to pay the tax, you have to comply with all the provisions. So therefore there is a section which is section 29 subsection 1 clause number C, which says that you can cancel your registration if you are no longer required to register under GST. So 29 subsection 1 clause number C says that if you are not liable to get yourself registered under GST because of the certain condition, like in case your turnover below 20 lakh rupees and you feel that your turnover will for every single year will be below 20 lakh rupees, then you can cancel your registration. Only after the effect of cancellation of registration, then only all the provision of this act will not be applicable to you, because when you will cancel the registration, it means that you will not call a registered person or the taxable person. Then only you will be free to not charge the GST from a client, and also then only you can say that all the provision will not be applicable to you. So as long as you are registered under GST, then you have to comply with every single provision of this act. But if you take the benefit of section number 29 subsection 1 clause C, which allow you to cancel your registration, then only you can set yourself free from the provision of CGST, SGST, IGST, UTGST, Compensation Act. The next question is regarding the category of person who are exempted to take registration under GST under section 23 subsection 2. And the question is, who are the person exempted under section 23 subsection 2? So before to answer this question, let me tell you something, that who are the section or what exactly section 23 subsection 2 says. Section 23 subsection 2 gives the power to the government to notify any category of goods or any category of a person who supply goods or services who can be exempted to take registration under GST. So it means that under section 23 subsection 2, government has the power to notify any kind of a person to exempt from taking the registration under GST. So the question is whether the government has notified any category of goods or services, any category of person who are exempted to take registration under GST under section 23 subsection 2. So the answer is yes, government has notified a person who is not liable to take registration under GST under notification number 5/2017, which is of dated 19 June 2017. And under this notification, the wording is that the person who are only engaged in making the supply of goods or services, the total tax of which need to be paid by the recipient of those goods or services under section 9 subsection 3 by way of a reverse charge. So the person who are only, underline the word only. So if a person who is only engaged in supplying of those goods or services, the tax on which is required to be paid by the recipient of goods or services under section 9 subsection 3 by way of a reverse charge, then the supplier of those goods or services need not to pay tax, need not to liable to register under GST. So therefore those kind of a person who's only engaged in supply those goods or services, the tax on which is required to be paid by the recipient of those goods or services, then those person need not to liable to take registration under GST. And the question is, who are the person who's only supplying those goods or services which the tax on which is required to be paid by the recipient under the reverse charge? The person is like, that is the example, like the GTA goods transport agency, when it supplies the service to certain kind of person, that is mentioned under the reverse charge notification, reverse charge decision, or those lists in which the reverse charge will be applicable. So you have to also check out the condition before saying that whether those person are not liable to take registration under GST or not. Okay, so those example, that is an example. So goods transportation agency, because if they supplies only the services of GTA, then he don't need to take registration under GST, because that is under the reverse charge. GTA service is under reverse charge. And similarly, when the advocate or the firm of advocate provide the legal services to any business entity, then also business entity need to pay tax under reverse charge. So therefore those advocate of the firm of advocate need not to take registration under GST. But if suppose those advocate also provide some other services, like apart from legal services, they also provide the services like filing of tax return or other kind of a service, then he need to take registration under GST, because the wording is the only engage in supply of goods or services which the tax on which is required to be paid by the recipient. So it means that if he supplies any portion of services outside the scope of the legal services, then he need to take registration under GST. Similarly, the arbitral tribunal are also exempted under section 23 subsection 2, and like the foreigner who are located outside India to a person who is located in India and the place of supply is in India, in those cases, because that will be taxable, GST will be payable by the recipient. So in that case, the foreigner who has supply of goods or services need not to take registration under GST under section 23 subsection 2. Read with notification number 5/2017 on 19 June 2017. The next question is for those person who want to rectify the detail which is provided at the time of registration of GST. So you ask the query because you got the message in your WhatsApp where it is written that you cannot change the return, you cannot change the tax payable under GST, or you cannot change the detail provided at the time of registration. You got the message in the WhatsApp group, and let me just tell you, it is all fake, or you can say it is untrue, because you can easily rectify the return, you can easily rectify the mistake done at the time of payment of tax, and likewise you can easily rectify the detail at the time of filing of registration. So the question is whether we can rectify the detail provided by taking the registration, and if yes, then how. So you can rectify the detail provided at the time of registration under section 28. Read with rule number 11 of registration. So you can rectify the detail, and section 28 clearly says that the rectification you can rectify the information provided at the time of registration, like you can rectify the detail like the address. So suppose you have the change in the address, then you can rectify it, and then change in the name of the company, firm, individual, etc. So if you want to change the name, and if you want to add or delete the person like the managing director, then the partner and trustees, etc., so you can easily done it. And that is the example only, address change in the then change in the partner or the director, or the change in the name, that is also example. So you can easily rectify the detail provided at the time of registration under section number 28 of CGST Act. And also you have to check out the rules, because in the rule the procedure is there. So I'm not going to tell you the whole procedure because that will be too lengthy. So if you want to check out the whole procedure, then you have to check out rule number 11 of registration rule. But I'm just giving you what type of form and within which time you have to file that form. So under rule number 11 there is a procedure that you have to file. You have to give the application in GST REG 14 form within 15 days of such changes. So whenever the name of the company changes, so within the 15 days of such changes you have to file an application in form GST REG 14. And after filing that form, the proper officer will also verify that form, and if he finds everything correct or true, then he will give you the order, and that order will become within 15 working days of filing of form under GST REG 14. So when you file the form, then he have to check this, the proper officer will check it within the 15 working days from the date of application, the date of receiving of form, GST REG 14 by the proper officer. But there are also a lot of condition or lot of procedure which you have to follow before amending the registration certificate. So if you want to check out, then you can check out the rule number 11 of registration rules. Alright guys, so thanks for watching the video. My next video would be on the RPQ on the transitional provision, and thereafter the RPQ on the job work, because a lot of people really don't know about the implication of GST on the job work. Also, because the GST is now going to applicable with effect from the 1st July 2017, and the government has lot to do before 1st July 2017. Therefore, the government will come up with a lot of notification, circular or announcement in the future. So therefore, I decided to do in the future a small clip where I will tell you the announcement which was there by the GST department. So therefore, in order to update you regarding the small announcement or notification in the future, I decided to give you the small clip where I just tell you the announcement. And also, because lot of time you really can't find out the notification, circular or the act rule from the CBEC or the new site of the GST Council, which is the www.gstcouncil.gov.in. So therefore, I decided to upload all those documents in my Google Drive so that you can easily download those documents from that drive. So that is also announcement which I am telling you right now. And also, over the period of 6 months, I received a lot of query and also replied it there too. Then I decided that because the RPQ which we are dealing right now is also the query, the query of those person, but sometimes the query is not relevant for all the guys. So therefore, I just dropped that query from entering in this video. So therefore, if you want to know all the queries, so I decided to upload all the query in form of a PDF in that same drive. So therefore, you can check that how the query is gonna solve, or how the provision of this act will apply in case that you have the same query. Or you can also educate yourself that how the provision of the CGST, SGST or other act will apply in case of your situation. So this will give you the little logic of how the provision of this act will going to apply on you. So therefore, I decided to upload all the queries in form of PDF in my Google Drive. So it will take some time. The link of that Google Drive will be given down in the description, not right now, but in the coming days, 4 or 5 days, I will upload the query. And also, if you have the query, then you can send me an email to sharwangst.148@gmail.com, sharwangst.148@gmail.com. Alright guys, so we will meet in the next video. Till then, bye bye.